Okay, let's sort of unpack this. Have you ever considered, how the law grapples with criminal intent that, well, never quite blossoms into a fully fledged crime?
It's a fascinating area.
Or perhaps how it holds those shadowy figures accountable, the ones pulling the strings from behind the scenes, maybe instigating others to commit illicit acts. Today, we're embarking on, I think, a genuinely fascinating deep dive. We're looking at critical aspects of criminal liability under India's new legislative framework, the Bhartiya Nyaya Sanhita 2023, or the BNS as we'll call it.
That's right.
We're going far beyond just the person who physically commits the crime, really venturing into the complex world of complicity and what the law calls inchoate offenses.
Those incomplete or preparatory crimes.
Exactly. Our insights today, they're drawn directly from a scholarly analysis of key sections of the BNS. Specifically, we're focusing on Chapter 4, which meticulously covers abetment, criminal conspiracy, and attempt.
A very crucial chapter.
We'll also briefly touch upon Chapter 5 that deals with offenses against women and children, but mainly just to set the stage for some future discussions we might have. So our mission for you today is really to distill the core concepts, examine the intricate nuances, and help you truly grasp the implications of these provisions. Think of it as maybe a shortcut to understanding how the BNS defines and punishes those who instigate, conspire, or merely attempt a criminal act. We aim to give you a concise yet hopefully profoundly thorough understanding.
And what's truly illuminating here, I think, is that while the BNS 2023 is obviously a very recent enactment, these particular sections we're delving into today represent a thoughtful evolution of longstanding principles.
Right, they didn't just appear out of thin air.
Not at all. Many of them are directly inherited from the now repealed Indian Penal Code of 1860. And understanding this historical continuity isn't just academic. It's absolutely crucial.
Why so crucial?
Because a vast body of existing jurisprudence developed over decades, over centuries really, will remain highly instructive in interpreting and applying this new Sanhita. So this deep dive, while it'll be precise in its legal commentary, it really aims to demystify what the law means for practical application.
Okay.
And, more broadly, for the entire criminal justice system, it's about understanding how this legal framework adapts to ensure comprehensive accountability across the whole spectrum of criminal involvement.
That's a perfect springboard. So when we talk about holding someone accountable for a crime they didn't physically commit, how does the law even begin to draw those lines? What's the very first step the BNS outlines for us in understanding this idea of complicity and abetment?
Well, that's precisely where Section 45 of the BNS comes in. You could call it the definitional cornerstone. It meticulously lays out what we call abetment.
Okay.
Now, this section is purely descriptive. It doesn't assign punishment yet. It sets the stage by outlining the actus reus, or the guilty act, of abetment.
The physical part, so to speak.
Exactly. Its core purpose is to penalize conduct that significantly contributes to an act's instigation, its planning, or its execution, even if that person isn't the direct perpetrator of the main offense. It acknowledges that criminal responsibility, it isn't confined to the person who pulls the trigger or delivers the final blow.
Makes sense.
So, Section 45 essentially tells us that a person abets the doing of a thing if they fall into one of three categories.
Three specific ways.
Three specific ways. Firstly, if they instigate any person to do that thing. Secondly, if they engage with one or more other persons in a conspiracy for doing that thing, but, and this is crucial, with the caveat that an actual act or an illegal omission must take place in pursuance of that conspiracy.
Ah, so not just the agreement.
Not just the agreement for this type of abetment. And thirdly, if they intentionally aid, by any act or illegal omission, the doing of that thing. These three modes, they really form the bedrock of understanding abetment.
Okay, let's maybe break those down a bit. Instigation first.
Let's do that. Abetment by instigation. This is all about actively inciting, urging, provoking, encouraging, or even goading someone into committing an act. It demands more than just being passively aware or, silently agreeing.
Right.
There has to be an active stimulation, a direct suggestion that prompts the action. Now, Section 45 goes further. It clarifies that this instigation can happen through willful misrepresentation, basically, deliberately giving false information.
Oh.
Or through willful concealment of a material fact that one is legally bound to disclose. Both of these can cause or attempt to cause an act to be done.
Can you give an example of that?
Sure. Think of this illustration. Imagine A, a public officer, is authorized to apprehend a known criminal named Z. Now B, knowing full well that C is not Z, deliberately misrepresents C as Z to A.
Yeah.
A, acting on this false information, apprehends C. Here, B has abetted the wrongful apprehension of C by instigation.
Through that lie.
Through that willful misrepresentation, it clearly highlights the mental element of B's deception and the direct causal link to A's action. And, pre-BNS jurisprudence under the old IPC consistently emphasized this need for active stimulation. It made clear that mere presence at the scene without active encouragement wouldn't count as instigation.
Got it. Active pushing is key.
Yeah.
What about the second mode? Conspiracy.
Right. Moving to abetment by conspiracy. This involves forming an agreement with one or more individuals for the doing of a thing. But here's a crucial distinction I mentioned earlier. For this to be abetment by conspiracy under Section 45, an overt act or an illegal omission must take place in furtherance of that conspiracy.
Ah, okay, so it needs a step beyond just agreeing.
Precisely.
Yeah.
This is fundamentally different from the substantive offense of criminal conspiracy itself under Section 61 of the BNS, which we'll hopefully get to later. For the standalone crime of criminal conspiracy, the agreement itself, in some specific cases, is enough. But for abetment by conspiracy, the law demands a tangible step, an act or omission taken towards the goal. This ensures that liability for this type of abetment is tied to a concrete manifestation of the plan.
Okay, clear distinction. And the third mode, intentional aid.
Finally, yes, abetment by intentional aid. This means exactly what it sounds like, intentionally assisting in the doing of a thing. That assistance can be either a positive act, like, say, providing a weapon or driving the getaway car, or it can be an illegal omission, where someone fails to do something they are legally obligated to do, and that failure aids the crime.
Like a security guard looking the other way.
Potentially, if they have a clear duty to act. Explanation 2 within Section 45 clarifies this aid can be provided prior to or at the time of the main act, specifically if it facilitates its commission. Now, this isn't about simply knowing a crime might happen. It's about actively assisting with a clear intent to make it easier for the principal offender. So holding open a locked door during a break-in, knowing it will help, would be intentional aid. Our past legal precedents always underscored that the aider must possess the intention to facilitate the crime. Mere knowledge without that intent isn't enough to establish abetment by aid.
That's an incredibly precise map of how abetment actually takes shape. So Section 45, it isn't just descriptive, it's really foundational, isn't it?
Absolutely.
It lays out the exact conditions, the how, for what constitutes abetment. The sheer breadth of preliminary or participatory conduct it covers is quite striking.
It is.
And while you mentioned the thing abetted doesn't always have to be an offense, it usually is, which I guess naturally brings us to Section 46. What truly stands out for me from Section 45 are those three distinct modes: instigation, conspiracy with an overt act, and intentional aid. And especially that emphasis on mens rea, the guilty mind for aiding.
Exactly.
Yeah.
And just to connect this to broader legal principles for a moment, we see Section 45 reflecting ideas like qui facit per alium facit per se. He who acts through another does the act himself.
Ah, the agency principle.
Right. It's a foundational principle where the law holds those liables who cause acts to be done by others. It's also a clear demonstration of inchoate liability, where abetment is treated as a preparatory crime, attaching responsibility even if the principal offense isn't fully completed. And this is a point Section 36 will really elaborate on.
So Section 45 defines what abetment is. Now, here's where it gets really interesting for the listener, I think. Section 46 tells us who an abettor is in a criminal context. It brings it all together, linking that defined act to real criminal culpability. This feels like where the theory translates into actual legal responsibility.
Absolutely. Section 46 is indeed pivotal. It establishes that abetment of an offense is itself an offense.
Right, standalone.
Quite independently of whether the abetted act is actually committed, or even if the person abetted was legally capable of committing it. Its core object is to hold instigators, conspirators, and aiders liable based on their own conduct and their own mens rea.
So the focus shifts to the abettor themselves.
Precisely. This means the law looks at your involvement and your intent, rather than simply piggybacking on the principal's actions or mental state.
Okay.
Section 46 states, a person abets an offense who abets either the commission of an offense or the commission of an act, which would be an offense, if committed by a person capable by law of committing an offense with the same intention or knowledge as that of the abettor.
That last part seems key, if committed by a person capable.
It is. This definition immediately introduces a critical concept, the innocent agent. It means an abettor can be held liable even if they use someone who, legally speaking, cannot be held responsible for the actual crime, perhaps due to age or mental capacity or even deception.
Ah, like using a child or someone unaware?
Exactly. Let's delve into its crucial explanations, because these really flesh out the nuances. Explanation 1 clarifies that you can abet an illegal omission even if you aren't personally bound by that duty.
Okay.
For example, if you instigate a hospital orderly who is bound by duty to illegally omit giving a patient their medication, you are guilty of abetment, even if you, as the instigator, had no such personal duty to administer medicine yourself.
So you're liable for instigating the breach of their duty.
Precisely. Then there's explanation 2, which I find truly fundamental. To constitute the offense of abetment, it is not necessary that the act abetted should be committed, or that the effect requisite to constitute the offense should be caused.
Wow, okay.
That's huge.
It is crucial. It means the offense of abetment is complete the moment the instigation, the conspiracy, with its required overt act, or the intentional aid is complete. It doesn't matter one bit whether the main offense is ultimately carried out or if the intended harmful effect actually materializes.
So the attempt, or rather the abetment itself, is the crime.
The abetment itself is the crime. Consider these powerful illustrations provided in the text. Illustration A describes A instigating B to murder C, but B, perhaps having second thoughts, refuses. A is still guilty of abetting murder.
Even though nothing happened to C.
Exactly. The crime of abetment was complete by A's instigation, or illustration B. A instigates B to murder. D. B actually stabs D, but D, against all odds, recovers. A is still guilty of instigating murder. It tells you that the criminal justice system can step in and hold people accountable for initiating harm, even if luck or circumstance prevents the worst outcome.
That's a really significant principle. What about explanation 3?
Explanation 3 is equally significant. It deals with the capacity and intent of the person actually committing the act. It states, "It is not necessary that the person abetted should be capable by law of committing an offense, or that he should have the same guilty intention or knowledge as that of the abettor, or any guilty intention or knowledge."
Okay, break that down.
It means an abettor's liability is independent of the legal capacity, the actual guilt, or even the intent of the person they abetted. The abettor is judged solely on their own mens rea, their own guilty mind.
So if the person doing the act is, say, insane.
That's exactly what the illustrations cover.
Yeah.
Imagine A with a clear guilty intent, abetting a child or an individual of unsound mind to commit an act that would be an offense if done by a legally capable person. A is guilty, whether the act is committed or not, because A possessed the necessary criminal intent.
Right.
Illustration B is a classic example. A instigates a child under 7 to cause Z's death. Because a child under 7 lacks criminal capacity under the law, the child commits no offense. Yet A is fully liable for murder.
Wow.
This vividly demonstrates the innocent agent principle. The law effectively treats A as the principal offender here.
Because A is the only one with criminal capacity and intent.
Correct. And in illustration D, A deceives B into believing stolen property is A's, causing B to take it. B, acting in good faith, commits no theft. But A is still guilty of abetting theft, emphasizing again that the abettor's mens rea is paramount.
Okay, that's clear. What's explanation 4?
Explanation 4 introduces the concept of abetment of abetment. The abetment of an offense being an offense, the abetment of such an abetment is also an offense. This establishes a derivative liability, a clear chain of criminal responsibility.
Like layers of instigation.
Exactly. If A instigates B to instigate C to murder Z, and C then commits the murder, both B for abetting C and A for abetting B to abet C are liable for murder. It ensures culpability extends to multiple layers.
Right, the responsibility tracks back up the chain.
And finally, explanation 5 addresses a crucial point specifically for abetment by conspiracy. It is not necessary to the commission of the offense of abetment by conspiracy that the abettor should concert the offense with the person who commits it. It is sufficient if he engages in the conspiracy in pursuance of which the offense is committed. It means you don't need direct interaction or even knowledge of the ultimate perpetrator. If A and B plan to poison Z, and B then involves C to procure the poison without ever naming A, and A subsequently administers it, C is still liable for murder because C was engaged in the conspiracy that led to Z's death, even without directly conspiring with A. It recognizes the sort of collective nature of criminal enterprise.
That's a truly comprehensive breakdown of the who and abetment. It really reveals the incredible breadth of this section, Section 46.
It does.
It defines the abettor and clearly establishes abetment as a distinct substantive offense. Its scope is remarkably wide, ensuring culpability isn't easily defeated by factors related to the principal offender or the outcome of the abetted act.
Hmm.
So the key takeaways seem to be abetment as a standalone crime, liability even when using innocent agents, the extension of responsibility through a chain of abetment, and that broad interpretation of conspiracy liability.
Absolutely. And from a theoretical standpoint, explanation 3 powerfully embodies the doctrine of innocent agency, where the abettors is effectively treated as the principal when using someone legally incapable of committing the crime.
Right.
And while abetment can sometimes appear derivative, tied to a principal offense, explanation 2 profoundly underscores its inchoate nature. The crime of abetment is complete in itself, independent of whether the final act is successfully completed.
That independence is key.
It is. And pre-BNS case law, particularly on the old IPC Section 108, consistently emphasized that the abettor's mens rea is paramount. An abettor can be punished even if the principal is acquitted, perhaps due to lack of capacity or intent. Hashtag 22. Extraterritorial reach of abetment, Sections 47 and 48 BNS 2023.
Okay, so we've defined abetment and who an abettor is pretty clearly, I think. But what does all this mean for, well, the global nature of crime today? In our interconnected world, criminal activities often transcend borders. How does India's legal framework, the BNS, extend its reach beyond its geographical limits for these kinds of complicity crimes?
That's a critical question, and it's precisely what Sections 47 and 48 address, the crucial aspect of extraterritorial application. These provisions are designed to ensure that India doesn't inadvertently become, say, a launch pad or a sanctuary for cross-border criminal enterprises.
Which is vital today.
Absolutely. A vital consideration in an age where criminal planning often disregards national boundaries completely.
So let's look at Section 47 first, abetting from India outwards.
Let's do that. Section 47, abetment in India of offenses outside India. Its core concept is straightforward. Establish Indian jurisdiction over acts of abetment that occur within India, even if the principal offense is committed abroad.
Okay.
The clear objective here is to prevent India from becoming a safe haven for planning or instigating international crimes. The critical condition, however, is that the abetted act, if it were committed domestically, would constitute an offense under the BNS.
So it has to be illegal in India, too.
Exactly. The provision states, a person abets an offense within the meaning of this Sanhita, who, in India, abets the commission of any act without and beyond India, which would constitute an offense if committed in India.
Pretty clear.
The basic requirements are clear. The abetment, as we've defined it in Sections 45 and 46, must take place in India. The abetted act is intended to be committed outside India, and crucially, that abetted act would be an offense if it had occurred within India.
Can you illustrate that?
Sure. The text gives a good one. A, while physically located in India, instigates B, who might be a foreign national in country X, to commit murder there. Under Section 47, A is guilty of abetting murder and is punishable in India, even though the actual murder happened abroad.
Because the instigation happened in India.
Precisely. This section is fundamentally jurisdictional, significantly extending the reach of Indian abetment law. Its scope is broad, applying to any person who abets an offense from within India, regardless of their nationality or the location of the principal offender, as long as the abetment happens on Indian soil and the abetted act aligns with Indian criminal law. A key feature here is what we call implied double criminality. This means the act abetted, if done outside India, must also be considered an offense under Indian law.
Right, you mentioned that.
This isn't just a legal technicality, it's a critical safeguard. It prevents India from prosecuting abetment of acts that might be perfectly legal or not considered criminal within its own legal system. It effectively respects the legal norms of other jurisdictions while still protecting India's own interests.
Makes sense.
This provision aligns with the territorial principle of jurisdiction for the abetment itself, and, indirectly, with the protective principle, which aims to safeguard international order by preventing the use of Indian territory for planning foreign crimes. The old IPC Section 108A operated similarly, based on the legal fiction that the offense of abetment is deemed committed in India.
That makes perfect sense. It's a vital mechanism for preventing India from being exploited as a base for criminal activities. But what about the reverse? What if the abetment takes place outside India, but the intended crime is targeted at India? How does the law address that kind of cross-border threat?
That's an excellent and equally critical point, and it's precisely where Section 48, Abetment outside India for offense in India comes into play. Its core concept is to extend Indian jurisdiction to abetment committed abroad if the principal offense is perpetrated or intended for within India.
Okay.
The object is very clear: to hold accountable those who orchestrate crimes impacting India from foreign locations, thereby directly protecting India's internal security and public order from external threats.
So catching the masterminds abroad?
Essentially, yes.
Yeah.
Section 48 reads, "A person abets an offense within the meaning of this Sanhita who, without and beyond India, abets the commission of any act in India which would constitute an offense if committed in India."
So the flip side of 47.
Exactly. The basic requirements here are the inverse of Section 47. The abetment, per Sections 45 and 46, occurs outside India. The abetted act is intended to be committed in India, and that abetted act would constitute an offense if committed in India.
And the illustration.
Imagine A, located in country X, instigating B to commit a murder in India. A is guilty of abetting murder under this section, even if A never sets foot on Indian soil.
Right.
Like Section 47, this is also a jurisdictional provision, specifically asserting India's extraterritorial jurisdiction. Its scope applies to any person who abets an Indian offense from abroad, regardless of their nationality. However, you can see the practical challenge. Enforcement. The practical enforcement of this provision often relies heavily on international cooperation, extradition treaties, and mutual legal assistance if the abettor is not physically present in India for trial. The salient feature is its direct focus on the location of the principal offense it must affect India. This provision is strongly rooted in the effects doctrine or objective territorial principle of jurisdiction, where a state can assert its authority over acts committed abroad that produce harmful effects within its borders. It also resonates deeply with the protective principle, which allows a state to claim jurisdiction over offenses that threaten its security, even if committed by non-nationals outside its territory. The old IPC Section 108A worked similarly, emphasizing the target offense in India as the key element.
Now that we've firmly defined what abetment is and how its reach can extend across borders, the next crucial step is, well, understanding how the law actually determines the punishment.
The consequences.
Exactly. The BNS seems to offer a truly nuanced approach here, acknowledging a whole spectrum of scenarios that can arise after an act of abetment. It seems incredibly complex, but also quite intriguing.
Indeed. These sections from 49 through to 52 are absolutely critical for delineating the quantum and the precise nature of an abettor's liability. They meticulously address situations where, say, the abetted act is committed.
Okay.
Or where the abetted person's intention might differ from the abettor's.
Right, we touched on that possibility.
Or where a completely different act is committed than the one intended, and even the possibility of cumulative punishment for multiple offenses. And in tackling these complexities, the BNS draws heavily on well-established principles from pre-BNS jurisprudence, which remain highly instructive for legal interpretation today.
So let's start with Section 49 then. What's the default rule?
Let's begin there. Section 49. Punishment of abetment, if act abetted, is committed in consequence and where no express provision is made for its punishment. This section establishes a crucial default rule for punishing an abettor.
Okay.
When the abetted offense is successfully committed as a direct result of their actions, and importantly, there's no specific punishment prescribed elsewhere in the Sanhita for that particular type of abetment.
Then what?
Then the abettor is held equally culpable as the principal offender. The object here is simple: to ensure that an instigator whose actions lead directly to the crime's fruition faces the same consequences as the person who actually carries it out.
Equal footing.
Equal footing in this specific scenario. The provision states, whoever abets any offense shall, if the act abetted is committed in consequence of the abetment and no express provision is made by the Sanhita for the punishment of such abetment, be punished with the punishment provided for the offense.
Okay.
So the key ingredients are abetment, as per sections 45, 46. The act abetted must be committed in consequence of that abetment, meaning a direct causal link. And importantly, there must be no express provision for the punishment of that specific abetment elsewhere in the BNS. The explanation section further clarifies this causal link, emphasizing that the act must be a direct result of the instigation, conspiracy, or aid that constituted the abetment.
And the examples.
Consider these illustrative examples. If A instigates B to give false evidence and B proceeds to do so, A is then liable for the exact same punishment as B. Or imagine A and B conspire to poison Z. A procures the poison, B administers it, and Z dies. In this scenario, B is guilty of murder. And A, having abetted by conspiracy which led to the murder, is also liable for the punishment for murder. This section is punitive, effectively equating the abettor's liability with that of the principal offender under these specific conditions. It's a form of vicarious liability in terms of punishment, and it crucially hinges on that direct causal connection.
That connection seems key.
It is. And pre-BNS IPC Section 109 similarly stressed in consequence of abetment as a critical element. It's also important to remember that if a specific provision for abetment, like, say, abetment of suicide, already exists elsewhere in the law, that specific provision would override this general default rule.
Got it. Section 49 is the default for successful abetment, but this raises that interesting challenge again. What if the person who actually commits the act has a different intention than the abettor? You mentioned this earlier. Does the abettor still face the same liability, or is their own intent the deciding factor here?
That's a crucial scenario, and it's precisely addressed by Section 50. Punishment of abetment if person abetted does act with different intention from that of abettor. The core concept here is fundamental. An abettor's liability is determined by their own primenter, mens rea their own intention or knowledge, and not by the actual doers.
Okay, so the abettor's mind is key.
Exactly. The object is to ensure the abettor is punished for the crime they intended or knew to be likely, even if the principal acted with a different intent, which might even lead to a different offense being committed by the principal, or, as we saw earlier with innocent agents, perhaps no offense at all on the principal's part.
Right.
The provision specifies, whoever abets the commission of an offense shall, if the person abetted does the act with a different intention or knowledge from that of the abettor, be punished with the punishment provided for the offense which would have been committed if the act had been done with the intention or knowledge of the abettor and with no other.
So, hypothetically, what the crime would have been with the abettor's intent.
Yeah. Precisely. The abettor is held liable for the offense that would have been committed had the act been performed with the abettor's specific intention or knowledge. This section acts as a very precise rule for determining the specific offense for which the abettor is liable, with a laser focus squarely on the abettor's state of mind. It applies specifically when there's a divergence in mens rea between the abettor and the principal actor. The key feature is that the abettor's mens rea is determinative, almost a form of constructive liability.
Can you give an example?
Sure. To give you an example, if A instigates B to cause grievous hurt, and A's intention is only to cause grievous hurt, but B, perhaps in a fit of uncontrollable rage, goes further and actually kills Z.
Okay.
In this case, A would still be liable only for abetting grievous hurt, based on A's original intent, despite the tragic death of Z.
Even though Z died?
Even though Z died because A's intent was limited. Conversely, if A instigates an innocent person, say a child, to administer what A knows is poison but tells the innocent person it's just medicine.
Right, the innocent agent scenario again.
A is liable for murder, irrespective of the innocent agent's complete lack of mens rea. This powerfully upholds the principle of individual culpability. Pre-BNS IPC Section 110 similarly established that an abettor's guilt is independent of the abetted person's guilt, focusing intently on the offense abetted by the abettor's own intent.
That's a very fine but absolutely critical line to draw, distinguishing between the abettors and the actual perpetrator's intentions. But what happens when the actual act committed is completely different from the one originally abetted, yet still somehow connected to the original plan? That sounds like it could open up a whole new level of legal complexity.
Indeed, and that's precisely where Section 51, liability of abettor when one act abetted and different act done, becomes critical. It introduces the robust and, frankly, often debated doctrine of probable consequence.
Probable consequence.
Okay. Its core concept is to extend the abettor's liability to acts not specifically abetted, but which were a probable consequence of the original abetment and were committed under its influence. The object is clear. Hold abettors responsible for foreseeable criminal acts that naturally flow from their initial illegal instigation, conspiracy, or aid. It prevents them from escaping liability just because the outcome wasn't perfectly aligned with their initial instruction.
So if something else happens, but it was likely to happen.
That's the gist. The provision states, when an act is abetted and a different act is done, the abettor is liable for the act done in the same manner and to the same extent as if he had directly abetted it, provided that the act done was a probable consequence of the abetment and was committed under the influence of the instigation or with the aid or in pursuance of the conspiracy which constituted the abetment.
Okay, so the provisos are key there.
Absolutely. The basic ingredients are: an act is abetted, A different act is subsequently done, and this different act must meet two conditions.
Mm-hmm.
It must be a probable consequence of the original abetment, and it must have been committed under the influence of that abetment.
The illustrations must be helpful here.
They are incredibly insightful for understanding this. Consider illustration A. A instigates a child to poison Z's food, even providing the poison.
Hmm.
The child, perhaps by mistake, puts the poison into Y's food, who fitting right next to Z.
Whoops.
Now, if the child was indeed acting under A's influence and poisoning Y was a probable consequence of abetting poisoning in that specific setting, maybe the plates were close together, etc.,
Yeah.
then A is liable for poisoning Y.
Even though Y wasn't the target?
Correct. It clearly shows liability extending to a mistaken target, if probable. Or take illustration. B. A instigates B to burn Z's house. B carries out the arson, but also commits theft of property from inside the house while it's burning. In this scenario, A is guilty of abetting arson, but not theft, because the theft was a distinct, improbable consequence of the act of burning itself. It wasn't a reasonably foreseeable part of burning the house down.
Right. One doesn't automatically lead to the other.
Exactly. Then there's illustration C, which is quite powerful. A instigates B and C to rob an inhabited house at midnight, even providing them with arms.
Hmm.
B and C break in, and being resisted by Z, one of the inmates, they murder Z.
Okay, escalation.
Now, if that murder was a probable consequence of abetting a nighttime armed robbery in an inhabited house, particularly when arms were provided,
Which seems plausible.
then A is also liable for murder. This powerfully illustrates that a graver offense can indeed be a probable consequence of the original abetment.
That's a significant extension of liability.
It is. This section fundamentally extends liability based on foreseeability, which is the very core of the doctrine of probable consequence. The test is objective. Would a reasonable person foresee the different act as a likely outcome, a natural flow from the original abetment? The causal link must always be maintained between the abetment and the different act. Pre-BNS IPC Section 111 case law consistently held that probable consequence means something likely to happen, not something remote or far-fetched. And it is ultimately a question of fact for the courts to determine in each case. Crucially, no liability attaches for acts that are entirely foreign or extraneous to the original abetment. This doctrine poses a significant challenge for a legal defense, as an abettor can't simply claim ignorance if a secondary, more serious crime was reasonably foreseeable given their initial criminal design.
That doctrine of probable consequence is truly key, then, ensuring abettors are held accountable for the sort of ripple effects of their actions. But what if the abetment leads to the originally intended act, a different probable consequence, and both of these are distinct offenses? Can the abettor actually be punished for both? That sounds like double punishment.
That's a very specific and indeed complex scenario, and it's addressed by Section 52. Abettor when liable to cumulative punishment for act abetted and for act done. The core concept here is that if abetment leads to the specifically abetted act and another distinct offense, which was a probable consequence under Section 51, the abettor can, in fact, be punished for both.
Really? Both?
Yes. The object is to hold the abettor accountable for all distinct criminal outcomes that legitimately flow from their abetment, preventing them from escaping full liability for the breadth of harm they caused or enabled.
Okay, so it's not double punishment for the same thing, but for two different things arising from the abetment.
Precisely. The provision is quite precise. If the act for which the abettor is liable under Section 51 is committed in addition to the act abetted and constitute a distinct offense, the abettor is liable to punishment for each of the offenses. So the basic ingredients are threefold. Firstly, the abettor must be liable under Section 51 for an act done, meaning a different but probable consequence. Secondly, this act done must be committed in addition to the act originally abetted. And crucially, it must constitute a distinct offense from the original one.
And the example clarifies this.
The illustration provides a very clear example. A instigates B to resist by force a distress made by a public servant. B resists, that's the abetted act, and in the course of that resistance, B voluntarily causes grievous hurt to the public servant. That's the distinct additional act. Here, B has committed two distinct offenses, resisting distress and causing grievous hurt.
Okay.
Now, if A knew that B was likely to voluntarily cause grievous hurt in resisting the distress, meaning it was a probable consequence in A's mind, then A would also be liable to punishment for each of those offenses, resisting distress and D causing grievous hurt.
So cumulative punishment is allowed there?
Correct. It explicitly permits cumulative punishment, which is an important exception to the general legal principle against punishing someone twice for the same set of facts. It's justified here because truly distinct offenses have been committed. The link to Section 51 is evident, as the additional offense must indeed be a probable consequence. The abettor's knowledge of the likelihood of this additional offense is pertinent for fixing liability for that specific distinct offense. This reflects the legal doctrines of distinct offenses and foreseeability and enhanced culpability. Pre-BNS IPC Section 112 similarly guided courts to carefully examine whether truly distinct offenses were committed. #Tag 5e. Advanced scenarios in abetment liability. Sections 53, 54, 55, 56, 57 BNS 2023.
We're continuing our deep dive now into the even finer points of abetment liability. These next sections, 53 to 57, they seem to explore even more specific and complex situations, further refining how the law attributes responsibility. This is truly where the intricate legal mind seems to shine, anticipating almost every permutation of criminal involvement, moving beyond the broader principles into very specific contexts.
Indeed, the Sanhita meticulously covers various permutations and subtleties of abetment. Sections 53 to 57 address a range of scenarios, from unintended effects that still hold the abettor liable due to foresight, to the significant impact of the abettor's physical presence at a crime scene, and even the abetment of uncommitted grave offenses or those involving large groups. And throughout these, the continued relevance of analogous principles from the IPC provides a strong interpretive foundation for these modern provisions.
Right. Let's start with Section 53 then. Effects different from intent.
Let's turn to Section 53. Liability of abettor for an effect caused by active abetted different from that intended by abettor. The core concept here is, again, extending an abettor's liability. This time, it's to the actual effect caused by the abetted act, even if that effect is different from what they initially intended.
But there's a condition, right?
Yes, the crucial condition. Provided the abettor knew the act was likely to produce that different, perhaps graver effect. The object is clear. Hold abettors accountable for foreseeable consequences of their abetment, preventing them from escaping liability for more serious outcomes if they possess that foresight or knowledge.
So it hinges on their knowledge again?
Knowledge is key. The provision is quite specific. When an act is abetted with the intention on the part of the abettor of causing a particular effect, and an act for which the abettor is liable in consequence of the abetment causes a different effect from that intended by the abettor, the abettor is liable for the effect caused in the same manner and to the same extent as if he had abetted the act with the intention of causing that effect, provided he knew that the act abetted was likely to cause that effect.
Okay, quite dense.
It is. So the basic ingredients are: an act is abetted with an intent for a particular effect. The act ultimately causes a different effect. And crucially, the abettor knew that the abetted act was likely to cause that different effect.
The illustration must help here.
The illustration provided makes this very clear. A instigates B to cause grievous hurt to Z. B carries out the act, causing grievous hurt to Z, but tragically, Z subsequently dies.
Okay.
Now, if A knew that the grievous hurt they abetted was likely to cause death, perhaps Z was frail or the intended injury was to a vital area, then A would be liable for abetting murder.
Even if their initial intent was just grievous hurt.
Correct. This section extends liability based on the abettor's foresight of probable consequences, specifically concerning the effect of the abetted act rather than a different act being done, which was Section 51. Here, the abettor's knowledge of likelihood is the key to establishing this form of constructive mens rea. Pre-BNS IPC Section 113 jurisprudence emphasized that knew implies direct awareness, requiring the prosecution to prove that actual knowledge of the likelihood was present in the abettor's mind.
That's a powerful way to ensure accountability, directly connecting an abettor's foresight to their culpability. Now, what about an abettor who is physically present when the crime is actually committed? Does that change their liability in a fundamental way, or are they still just seen as an abettor?
Yes. It absolutely changes everything. That brings us to Section 54. Abettor present when offense is committed. This section establishes a really significant rule. The physical presence of an abettor at the crime scene elevates their role from a mere abettor to a principal offender.
Wow. Okay, so they're treated as if they did it themselves.
Exactly. They are legally deemed to have committed the act or offense itself. The object here is to recognize such presence not just as passive support, but as direct participation, active encouragement, or a clear readiness to assist, reflecting a deeper and more direct involvement in the perpetration of the crime.
Right, their presence adds weight.
Immense weight. The provision reads, Whenever any person who is absent would be liable to be punished as an abettor is present when the act or offense for which he would be punishable in consequence of the abetment is committed, he shall be deemed to have committed such act or offense.
Simple but powerful.
The basic requirements are straightforward. A person would be liable as an abettor if they were absent from the scene, and that same person is physically present when the offense is committed. The legal consequence is automatic. They shall be deemed to have committed such act or offense.
So it's a legal fiction almost.
It's a deeming provision, essentially a rule of constructive liability. It legally transforms the abettor into a constructive principle, which has significant implications, especially for sentencing. Now, presence here implies sufficient proximity to actively encourage, aid, or assist.
Not necessarily right beside the person.
Not necessarily in the exact spot, but close enough to exert influence or be ready to intervene. For instance, if A instigates B to assault Z, and A then stands nearby, perhaps shouting encouragement while B carries out the assault, A is deemed to have committed the assault directly, not merely abetted it. This aligns with common law concepts like principles in the second degree and can serve as strong evidence in a joint criminal enterprise. Pre-BNS IPC Section 114 jurisprudence clarified that presence means physical proximity to assist or encourage, and importantly, the conditions for abetment must first be met, with the abetment itself being complete before the offense is committed.
So proximity really does fundamentally change an abettor's legal standing. Now let's consider the punishment for scenarios where the abetted crime is extremely serious, like one punishable with death or life imprisonment, but the crime isn't actually committed. How does the BNS handle that kind of incomplete but gravely intended criminal enterprise?
This is directly addressed by Section 55. Abetment of offense punishable with death or imprisonment for life. Its core concept is that even abetting an uncommitted grave offense is itself a serious crime deserving substantial punishment.
Right.
The explicit object here is to strongly deter the instigation or aiding of plots for offenses punishable with death or life imprisonment, even if those plots ultimately prove unsuccessful. Furthermore, it imposes a significantly higher punishment if any hurt results from the abetted act, even if the ultimate grave offense doesn't materialize.
So different levels of punishment depending on outcome.
Yeah, exactly. The provision outlines two distinct tiers of punishment. Whoever abets the commission of an offense punishable with death or imprisonment for life shall, if that offense be not committed in consequence of the abetment, and no express provision is made, be punished with imprisonment for a term which may extend to 7 years, and shall also be liable to fine. And if any act for which the abettor is liable, and which causes hurt to any person is done, the abettor shall be liable to imprisonment for a term which may extend to 14 years, and shall also be liable to fine.
Okay, 7 years if nothing happens, 14 if hurt is caused.
Correct. So the basic ingredients are abetment of an offense punishable with death or life imprisonment, the crucial element that the principal offense is not committed, and the absence of any other express provision for that specific abetment. If the offense is not committed and no hurt is caused as a consequence of the abetment, the punishment is imprisonment up to 7 years plus a fine. However, if any act causing hurt, as defined in the Sanhita, is done as a consequence of the abetment, the punishment is significantly enhanced to imprisonment up to 14 years plus a fine. The illustration clearly shows A instigating B to murder Z. If B refuses, A faces up to 7 years. If B stabs Z, causing hurt but not death, A faces up to 14 years.
That's quite a jump.
It is. This is a specific punitive provision for uncommitted serious offenses, showcasing a clear, graduated punishment based on the level of harm that actually occurred. It powerfully highlights the principle of inchoate crime punishment and the strong policy of deterrence at the earliest stages of grave criminal intent. Pre-BNS IPC Section 115 similarly required the non-commission of the principal offense.
That's a very strong deterrent for even the mere thought or planning of grave crimes. What about abetment of less severe imprisonable offenses when they're not ultimately committed? And importantly, does the involvement of a public servant, someone sworn to uphold the law, change the equation for these lesser offenses?
It absolutely does. That's the specific focus of Section 56. Abetment of offense punishable with imprisonment. This section penalizes the abetment of imprisonable offenses, excluding, of course, those punishable with death or life imprisonment, which Section 55 covers.
Yeah.
This applies even if the abetted offense is not ultimately committed.
Okay.
The primary object here is to deter such abetments across a broader range of crimes. Critically, it imposes a more severe penalty if a public servant is involved, highlighting the grave nature of their breach of duty and the trust placed in them.
So a higher standard again.
A significantly higher standard. The provision details two distinct punishment tiers. Whoever abets an offense punishable with imprisonment shall, if that offense be not committed, be punished with imprisonment, for a term which may extend to 1/4 part of the longest term provided for that offense, or with such fine, or with both. And if the abettor or the person abetted is a public servant, whose duty it is to prevent the commission of such offense, the abettor shall be punished with imprisonment, for a term which may extend to 1/2 of the longest term provided for that offense, or with such fine, or with both.
1/4 normally, but 1/2 if a public servant is involved in preventing it.
Correct, if the public servant's duty was to prevent that specific offense. So the basic ingredients are abetment of an imprisonable offense, excluding death life, the offense not committed, and no express provision elsewhere. Generally, the punishment is imprisonment up to 1/4 of the longest term for the principal offense, or a fine, or both. However, if either the abettor or the person abetted is a public servant whose duty it is to prevent that specific offense, the punishment is significantly enhanced to imprisonment up to 1/2 of the longest term for the principal offense, or a fine, or both.
The illustrations must make this clear.
They do.
Right.
A instigates B to give false evidence. B ultimately does not. A is liable for up to 1/4 of the maximum imprisonment for false evidence. B, a police officer whose duty is to prevent robbery abets a robbery. Even if no robbery occurs, A is liable for up to half the longest term provided for robbery, reflecting their heightened culpability.
Right.
And C, similarly, if B abets A police officer, to commit robbery and the robbery is not committed, B is also liable for up to half the longest term. This showcases a system of fractional punishment and a clear enhanced liability for public servants due to their egregious breach of public trust. Pre-BNS IPC Section 116 operated on similar principles.
That's a very clear way to differentiate culpability based on both the severity of the uncommitted crime and the critical role of public officials. Finally, in this set, what about abetment that targets not just an individual, but a large group like the public generally, or maybe more than 10 people? That feels like it could have widespread, chaotic consequences, a totally different dimension of criminality.
You're absolutely right. It introduces a completely new dimension. That's precisely why Section 57, abetting commission of offense by public or by more than 10 persons, is so important. Its core concept is to specifically penalize the abetment targeting a large group, either the public generally or any number or class of persons exceeding 10.
Why the specific number 10?
That's the threshold the legislature set, likely deeming that abetting more than 10 people presents a significantly higher risk of mass action or disorder compared to smaller groups. This provision recognizes the heightened potential for widespread disorder, public mischief, or the large-scale commission of offenses that such incitement can unleash. The explicit object is to deter mass incitement and protect public order.
Makes sense. And the provision?
The provision is straightforward. Whoever abets the commission of an offense by the public generally, or by any number or class of persons exceeding 10, shall be punished with imprisonment of either description for a term which may extend to 7 years and with fine.
So a flat potential penalty up to 7 years.
Correct. The basic ingredients are abetting an offense, and that abetment must be directed towards the public generally or any number or class of persons exceeding 10. The punishment specified is imprisonment up to 7 years and a fine. This is effectively a substantive offense of abetment, specifically tailored for mass incitement. Its scope applies regardless of whether the offense is actually committed by the public or the large group. The mere act of abetting such a large body of persons is in itself the offense, reflecting the grave potential for harm. The salient features are its focus on the scale of abetment and the inherent threat to public order and safety.
And the illustration.
The illustration provided is classic. A fixes a placard instigating a sect, which has more than 10 members, to attack an adverse sect during a public procession. A, by that act alone, has committed the offense under this section, regardless of whether the attack actually happens. This provision clearly embodies elements of public order offenses and targets an aggravated form of incitement. Pre-BNS IPC Section 117 used similar broad terms and the specific numerical threshold. #TagBI, Concealing Criminal Designs, Criminal Conspiracy and Attempt, Sections 58, 59, 60, 61, 62, BNS 2023.
We move now to some of the most intricate areas of criminal law crimes that deal with the very intention and planning stages, often long before the main offense might even be committed. Here's where it gets really interesting, I think, especially with the BNS introducing crucial updates for our increasingly digital age. That feels incredibly relevant and forward-looking.
Absolutely. This final segment of our deep dive into Chapter 4 is crucial for understanding how the law tackles preparatory acts and concerted criminal designs, really focusing on foresight and intention. Sections 58, 59, and 60 address the serious offense of concealing criminal designs.
Hiding the plan.
Exactly. While Section 61 defines and punishes criminal conspiracy, the agreement itself, and Section 62 provides a general framework for attempts. Now, the established jurisprudence from the IPC remains invaluable here, guiding the interpretation of these modernized provisions, particularly as new technologies like encryption come into play. It reflects the law's attempt to keep pace with evolving criminal methods.
Okay, let's start with concealing designs. Section 58. Grave offenses first.
Let's begin there. Section 58. Concealing design to commit offense punishable with death or imprisonment for life. This section criminalizes the act of voluntarily concealing a known design to commit very serious offenses, those punishable with death or life imprisonment, or making false representations about such designs, specifically with the intent to facilitate their commission, or knowing facilitation is likely.
So, actively hiding a plot for a major crime.
Correct. Its core object is to impose a legal duty, essentially, not to actively or passively aid serious criminal designs by suppression or misinformation. It aims to deter any conduct that shields such dangerous plans from discovery and prevention. Section 58 is quite detailed. Quote, whoever intending to facilitate or knowing it to be likely that he will thereby facilitate the commission of an offense punishable with death or imprisonment for life, voluntarily conceals by any act or omission or by the use of encryption or any other information hiding tool the existence of a design to commit such offense, or makes any representation which he knows to be false respecting such design shall, A, if that offense be committed, be punished with imprisonment, B, if the offense be not committed, with imprisonment.
Okay, that mention of encryption is striking.
It is a significant modern update. The basic ingredients include a specific mens rea, either an intention to facilitate the crime or knowledge that such facilitation is likely. The actus reus is the voluntary concealment of a design to commit an offense punishable with death or life imprisonment. This concealment can happen by any act or omission, or, and this is the key update, by the explicit use of encryption or any other information hiding tool.
So, using tech to hide plans is explicitly covered?
Explicitly. Alternatively, the actus reus can involve making a representation that the person knows to be false regarding such a design. The punishment is carefully graded. Up to 7 years imprisonment and a fine if the principal offense is committed, and up to 3 years imprisonment and a fine if the offense is not committed.
In the example.
The illustration of A, knowing about a planned dacoity at place B, but falsely informing the magistrate its plan for place C, in the opposite direction, specifically to mislead and facilitate the dacoity at B that clearly demonstrates this. If the dacoity happens at B, A is punishable under this section.
Right.
This section is a substantive offense punishing aid through concealment or misinformation, notably updated to include modern digital concealment methods. It shares characteristics with being an accessory after the fact, though it's distinct, happening before the crime often, and implicitly imposes a duty not to facilitate serious crime. Pre-BNS IPC Section 118 similarly required voluntary concealment and a specific design to be proven. The inclusion of encryption here is particularly striking because it shows the law specifically adapting to the tools of the digital age.
That inclusion of encryption is indeed a really forward-looking update, showing the law's agility. So the legal system is actively trying to adapt to how crimes are planned today. But what if the person concealing this design is a public servant? Someone whose very job it is to prevent such crimes. That feels like a double betrayal of trust and duty.
Absolutely, it is, and that's precisely what Section 59, public servant concealing, designed to commit offense, which it is his duty to prevent, addresses. This is an aggravated form of the offense of concealment. Its core concept is the heightened culpability of a public servant who, in direct breach of their specific duty to prevent an offense, intentionally facilitates it by concealing its design. The object is not only to uphold the integrity of public service, but also to ensure that public servants fulfill their crucial duty to prevent crime. It imposes harsher penalties for such dereliction and complicity, recognizing the severe breach of public trust.
So the stakes are higher.
Much higher. The provision's structure is similar to Section 58, but it critically begins. Whoever, being a public servant, intending to facilitate or knowing it to be likely that he will thereby facilitate the commission of an offense, which it is his duty as such public servant to prevent, voluntarily conceals, or makes any representation which he knows to be false respecting such design shall.
Right, the public servant and duty to prevent clauses are upfront.
Exactly. So the basic ingredients require the accused to be a public servant, as defined in Section 228 BNS, with a specific duty to prevent the offense, coupled with the requisite mens rea, intent or knowledge of facilitation, and the actus reus of voluntary concealment or false representation, which, notably, again, explicitly includes encryption or other information hiding tools.
Same digital update there, too.
Yes. The punishment structure here is quite complex and highly graded to reflect the severity. If the offense is committed, generally, imprisonment is up to 1/2 the longest term for the principal offense, or a fine, or both.
Okay.
If the offense committed is punishable with death or life imprisonment, the punishment for the concealing public servant can extend to a significant 10 years imprisonment.
Wow, 10 years just for concealing.
If the main crime happened, yes. If the offense is not committed, the punishment is up to 1/4 of the longest term for the principal offense, or a fine, or both. The illustration of a police officer, whose duty it is to report robbery designs, deliberately omitting to give information with intent to facilitate a robbery, perfectly exemplifies this. This is clearly an aggravated form of concealing a criminal design specific to public servants, where the breach of duty is paramount, leading to significantly higher penalties. This provision strongly reflects the breach of public trust doctrine and principles of aggravated liability. Pre-BNS IPC Section 119 required similar proof of status and duty.
That distinction makes perfect sense. Public servants are rightly held to a higher standard. So Section 58 covers general concealment for grave crimes, and Section 59 deals with public servants doing the same with enhanced penalties. Is there provision for concealing designs for less serious but still imprisonable offenses, extending this concept more broadly?
Yes, there is, ensuring comprehensive coverage. That's addressed by Section 60. Concealing design to commit offense punishable with imprisonment. This section criminalizes facilitating less grave, imprisonable offenses by deliberately concealing their design or making false representations about them.
So, covering the rest.
Covering the rest of the imprisonable offenses. Its core object is to deter individuals from aiding this broader range of offenses through concealment, extending the principle beyond just those punishable with death or life imprisonment. The provision states, whoever, intending to facilitate or knowing it to be likely that he will thereby facilitate the commission of an offense punishable with imprisonment, voluntarily conceals.
Yeah.
Shall, A, if the offense be committed, be punished with imprisonment. B, if the offense be not committed, to 1/8.
Okay, fractional punishment again.
Fractional punishment, yes. The basic ingredients are the familiar mens rea of intent or knowledge of likely facilitation, and the actus reus of voluntary concealment, by act or illegal omission, implicitly including digital means, or false representation. The target offense here is any offense punishable with imprisonment, but not necessarily death or life imprisonment, thus encompassing a much wider range of crimes.
Right.
The punishment is proportional and graded. If the offense is committed, imprisonment is up to 1/4 of the longest term for the principal offense, or a fine, or both. If the offense is not committed, it's up to 1/8 of the longest term, or a fine, or both. This section constitutes a substantive offense, penalizing concealment for this wider range, with punishment directly tied as a fraction to the principal offense's maximum term. This is another facet of the broader principle of complicity. Pre-BNS IPC Section 120 works similarly.
So, we've meticulously covered individuals concealing designs for grave crimes, public servants doing the same with enhanced penalties, and then general concealment for all other imprisonable offenses. That's incredibly thorough in trying to stop crimes before they even start. Now let's pivot to criminal conspiracy, which, as you mentioned earlier, is the crime of the agreement itself. How does the BNS define and punish that critical meeting of minds?
This is truly a cornerstone of preparatory criminal law in Section 61. Criminal conspiracy defines it with precision. The core concept is that an agreement between two or more persons to commit an illegal act or a lawful act by illegal means constitutes a distinct offense.
The agreement itself is the crime.
In many cases, yes. The object is profound, to penalize the very formation of a criminal agreement, recognizing the significant threat it poses to society even before any actual execution. It targets concerted criminal action at its very incipiency, the moment minds meet to pursue illicit ends.
How is it defined?
Subsection 1 provides the definition. When two or more persons agree with the common object to do, or cause to be done, A, an illegal act, or B, an act which is not illegal by illegal means, such an agreement is designated a criminal conspiracy.
Okay.
So the basic ingredients are an agreement between two or more persons with a common object to do or cause to be done, either an illegal act, which itself can be an offense, something prohibited by law or even just a ground for civil action, or a non-illegal act by illegal means.
Right, but there was a key difference you mentioned earlier.
Exactly. Crucially, there's a proviso that creates a key distinction. Provided that no agreement except an agreement to commit an offense shall amount to a criminal conspiracy unless some act besides the agreement is done by one or more parties to such agreement in pursuance thereof.
Okay, break that down again.
It means that if the agreement is to commit a defined offense under the law, like murder, theft, etc., the agreement itself is sufficient for the crime of conspiracy. No overt act is necessarily needed beyond the agreement itself. This is what makes it so powerful for prosecuting organized crime.
Right, catches the plot early.
However, if the agreement is for an illegal act that isn't strictly an offense, like, say, a civil wrong or breaching a contract through illegal means, or a lawful act by illegal means, then an overt act in pursuance of the agreement is absolutely essential to constitute the conspiracy. The explanation further clarifies that it's immaterial whether the illegal act is the ultimate object or merely incidental to the agreement.
Got it. Offense versus non-offense agreement matters for the overt act and punishment.
Subsection 2 outlines the punishment. For a conspiracy to commit serious offenses, those punishable with death, life imprisonment, or rigorous imprisonment of 2 years or more. If no express provision for its punishment exists elsewhere, the conspirator is punished as if they had abetted such offense.
Linking back directly to abetment punishment.
Directly linking back. For other conspiracies, those targeting less serious acts or non-offenses, the punishment is imprisonment up to 6 months or a fine or both. This highlights the nature of conspiracy as a substantive, inchoate offense, where the agreement itself is the essence of the crime, especially for more serious targets. The concept of a meeting of minds, consensus ad idem, is central, though direct proof is often challenging, typically inferred from conduct and circumstantial evidence, as seen in older cases like State of Maharashtra v. Somnath Thapa. It's an inchoate crime because it's punished even if the ultimate act isn't accomplished.
That's a powerful tool against organized crime, designed to catch it at the very planning stage. Finally, what about the very last step before a crime is completed? When someone attempts to commit an offense but fails, how does the BNS handle that critical stage where intent...
An attempt to commit an offense, even if unsuccessful, is itself a punishable wrong.
The attempt itself is a crime.
It is. The object is twofold: to deter individuals from even progressing toward the commission of crimes, and to recognize the inherent social danger posed by such attempts. This section provides a general penalty for attempts where the Sanhita does not specify a particular punishment for the attempt of a specific offense, as some specific attempts, like attempt to murder, have their own dedicated sections.
So this is the catch-all for attempts.
It's the general residual provision for attempts, yes. The provision states, whoever attempts to commit an offense punishable by this Sanhita with imprisonment for life or imprisonment, or to cause such an offense to be committed, and in such attempt does any act towards the commission of the offense, shall, where no express provision is made, for the punishment of such attempt be punished with imprisonment, for a term which may extend to 1/2 of the imprisonment for life, or, as the case may be, 1/2 of the longest term of imprisonment provided for that offense, or with such fine, or with both.
Half the sentence of the full crime, potentially.
Up to half, yes. The basic ingredients are an attempt to commit an offense punishable with life or any term of imprisonment, or an attempt to cause such an offense to be committed. The accused must do any act toward the commission of the offense. This is a critical distinction from mere preparation, and there must be no express provision for the punishment of that specific attempt elsewhere in the BNS. The punishment is imprisonment up to 1/2 of the life imprisonment term, which for calculation is often considered 20 years per Section 6 BNS, or 1/2 of the longest term of imprisonment provided for that principal offense, or a fine, or both.
And the illustrations here are interesting.
They are. They clearly highlight a crucial principle that factual impossibility is generally no defense for an attempt.
Meaning?
Illustration A describes A attempting to steal jewels by breaking open a box, only to find, perhaps to their dismay, no jewels inside. A has still done an act unequivocally towards theft and is guilty of attempt.
Even though there's nothing to steal.
Correct. Similarly, in illustration B, A attempts to pick Z's pocket, but Z happens to have nothing in it. A is still guilty of attempted theft. This section is a general punitive provision for the inchoate offense of attempt. Its scope covers most imprisonable offenses under the BNS. The crucial aspect here is what constitutes any act towards commission. It must go beyond mere preparation and be proximately connected to the actual perpetration of the offense.
That preparation versus attempt line must be tricky.
It's notoriously tricky. This provision strongly reflects the nature of inchoate crime, ensuring the justice system can intervene once a clear step towards a crime has been taken, even if success is thwarted. Pre-BNS IPC Section 511 jurisprudence, in cases like State of Maharashtra v. Mode, Yaqub extensively debated this challenging distinction, emphasizing that an attempt begins when acts are unequivocally directed towards the crime, past the point of mere planning or locus potentiae, the opportunity to withdraw. #outdraw.
Wow. What an incredible deep dive. We've really journeyed through our vast and, frankly, intricate landscape of criminal liability today, from the instigators and conspirators who set crimes in motion to those who merely attempt a crime, and even those who try to conceal the very intention of it all. It's truly an intricate web of accountability designed to capture culpability at every stage.
Indeed. And if we connect this to the bigger picture, these provisions of the BNS 2023 powerfully underscore a fundamental principle of criminal law. That accountability extends far beyond the direct physical commission of a crime.
Right. It's not just about the final act.
Not at all. It recognizes the insidious nature of planning, instigation, and aiding, ensuring that society can intervene and hold individuals responsible even before the full intended harm materializes. The meticulous detail in these sections, I think, reflects a sophisticated legal approach, one that adapts to modern complexities while steadfastly retaining foundational principles of public order and justice.
And that reach is absolutely essential for a stable society, isn't it? Knowing that the law has this kind of foresight and breadth. So what does this all mean for you, our listener, as a learner? Well, hopefully you now possess a comprehensive understanding of the intricate web of liability that extends to complicity and uncompleted acts. It should provide a much deeper appreciation of criminal jurisprudence and the foresight embedded within India's new legal framework.
And this raises, I think, an important question for further thought, something perhaps to mull over. How will the explicit inclusion of encryption and other information hiding tools in the BNS sections concerning concealment of criminal designs, how will that continue to shape legal interpretation, investigative methodologies, and indeed enforcement in our increasingly digital world?
That's a huge question.
It is. It's a testament to the law's attempt to, but its practical implications for things like evidence gathering, individual privacy, digital forensics, well, they're still unfolding. It presents both profound opportunities and, frankly, significant challenges for the justice system going forward.
A truly provocative thought indeed for you to mull over and perhaps explore further. Thank you so much for joining us on this deep dive into the Bhartiya Nyaya Sanhita 2023. We look forward to our next exploration with you.